welcome to the Legal Lounge here on CRN Digital Talk Radio, streaming live coast to coast and around the world on crntalk.com. Also available in stunning high-definition video on facebook.com/CRN Talk. Join us there. We have Bruce in the chat room. What's up, Bruce? Also available on crntalk.com, on Tiki Live, also on CRN's custom-built Roku channel. You can find that for free in the Roku store. And I'm joined, as always, by the one and the only, an active attorney, U.S. Army veteran, Juris Doctorate in Law, undergraduate degree in physics, and author of a book that has proven to be a guideline for the Supreme Court now and in the future. That book, America, An Illusion of Freedom, is available on Amazon.com, BarnesandNoble.com, and on iTunes. Ladies and gentlemen, the one and the only, Mr. Richard Nixon. Sir, how are you?
Thank you. I'm fine, Mike. And you?
Doing very well, thank you.
Good. However, I am, if you will, I'm a bit crestfallen, if you will, to find another fellow attorney who seems to be going awry. Filing this ridiculous lawsuit against Mr. Trump is strictly based on politics. I guess he figures he'll somehow, that is, Mr. Bragg, will somehow benefit from this case. But without going through all the details, I can't imagine if he's before a neutral judge how Mr. Bragg is going to succeed in this manner. Statute of limitations seems to be against him. He's filing a federal filing in state court for a federal statute. It goes on and on. And one thing I should mention too is a prosecutor has a duty not to get somebody. He has a duty to do justice, and therefore, if there's any exonerating evidence, the prosecutor, as opposed to a private attorney, must turn over that evidence, and I'm hoping that's what will happen here.
Of course, we're talking about the big news of the week, of course, the indictments that Mr. Trump has been indicted. He will appear in New York City on Tuesday to enter a plea at his arraignment. And like you said, this is a case, we're going to talk about it throughout the show. It should be noted, too, that Mr. Alvin Bragg, he's the elected Manhattan DA.
Right.
He has decided to move forward with his grand jury indictment, even after his predecessor decided not to file charges, even though that the Southern District of New York federally declined to file charges. And also, this particular matter was looked into by the Federal Elections Committee, the FEC, and they decided not to take any action. So real fast, Richard, is this because Alvin Bragg's elected, and he's elected one of the most liberal jurisdictions in all of America, that he feels like he has to do this?
Well, I think it's also because who's the guy that gives he's the billionaire that gives all the money to these...
George Soros.
Yeah, exactly. I think he's committed himself to the devil here, George Soros, and he must do his bidding. And somehow, if he doesn't succeed in nailing Trump, if you will, he'll be enumerated somehow. But in any event, like I said, it's a sad day for all of us attorneys who care about attorneys being ethical and doing the right thing.
About elected members of the judicial body acting politically rather than the interest of justice,
exactly.
As it seems we might have in this case. Stick around, you guys. We're going to talk more about this right after the break. Stay with us.
Attention real estate investors. Do you need cash immediately? If you own one or multiple rental properties, you can use your equity to get cash out fast. The best part is we don't need tax returns or even a good credit score. At America's Loan Source, we are not a bank and we don't have bank rules. We make the decisions to loan you money, and there's no limit how much we can give you. Some clients have gotten as much as $500,000 or more within days. Use the money any way you want. If you own one rental property or 100 and COVID has left you in a cash crunch, we can help you turn your equity into fast cash. Call now for details and close in as little as 10 days and get the cash you need. 800-353-1760. 800-353-1760. 800-353-1760. That's 800-353-1760.
And we are back in the Legal Lounge. Once again, thank you so much for joining us here on CRN Digital Talk Radio. Richard, thank you for pointing out this great music to me.
Oh, it's great.
Fantastic. All right, appreciate it. Shout out to Pancho Sanchez. Let's talk a little bit more about this Trump indictment. According to reporting based on anonymous sources close to the investigation, attorney Manhattan DA Alvin Bragg is relying mainly on a state law that makes it a misdemeanor to falsify business records with intent to defraud.
Right.
Trump, who has reimbursed Mr. Cohen for allegedly hush money payments to Daniels, allegedly broke that law when his business misrepresented the reimbursement as payment for legal services under a non-existent retainer agreement. A couple things here. First of all, falsification of business records is a misdemeanor.
Correct.
However, falsification of business records becomes a Class E felony, punishable by 4 years in the joint when the defendant's, quote, intent to defraud includes an intent to commit another crime or to aid or conceal the commission thereof. Campaign finance violations,
yes.
I imagine here.
Yes.
Real fast, though, the statute of limitations regarding these particular charges have lapsed. For the misdemeanor, it's 2 years. For the Class E felony, it's 5 years.
It would seem so, yes.
This is 6 years after the fact. What's going on? First of all, what's going on here?
Well, again, people have been tossing the term tolling around. That is to say, there are times when the statute of limitations is stopped or tolled against the defendant. One of them is when he leaves the jurisdiction. However, that leaving the jurisdiction is not dispositive of the issue. He must leave the jurisdiction and become unavailable to the plaintiff. So if the plaintiff can still serve him with papers, then nothing tolls. And in this case, of course, it's clear Trump was always available to be sued. There was really no reason to wait all these years. So I think tolling would be a frivolous defense, to be honest with you. The other thing that I don't quite get in this case is the fact that with all the people that have gone against filing this paper, these charges against Mr. Trump, how Mr. Bragg seems to think that somehow it's going to succeed. I think it won't.
Well, maybe he's doing it for symbolic reasons. Maybe it's just purely political, and Mr. Bragg doesn't really care if he successfully gets a conviction on any of these 36 charges.
Yes, but if we know that, if the court knows that, he can end up losing his license for filing a misleading or fraudulent case. He might be subject to malicious prosecution as well, where a person or an attorney absolutely knows there's no merit to the case he's filing. He files anyway, and he loses, of course, malicious prosecution. He could be in a lot of trouble.
He could face sanction from the state bar.
Absolutely.
As well. Real fast, just to return to this tolling issue, tolling the statute of limitations.
Right.
The whole purpose of that is that, let's say I commit a crime.
Right.
And I know that the judgment is coming on down, that the cops are after me, and I go on the lam.
Right.
And it's so, like, let's say I go on the lam, I rob a bank, and I go on the lam, and then the statute of limitation, which I believe for bank robbery is 10 years, and I come back 11 years later, they can still charge me because I intentionally and willfully tried to flee from prosecution.
If they couldn't find you, but if they knew, for instance, if you left here in California and you went to Las Vegas and they knew you had gone to Las Vegas, that is, you were amenable to service, then the statute doesn't toll. And if you come in after 11 years, you will be nailed.
But I mean, Mr. Trump they knew where he was. He was at 1600 Pennsylvania Avenue.
Absolutely.
And now he's down at Mar-a-Lago. I mean,
Right.
the man's on TV all the time.
Yeah. So, but again, these are the talking heads on TV that are giving some possible defenses that Mr. Trump, or I should say, Mr. Bragg would have for why the statute hadn't run. But being an armchair attorney here, at least today, I think Mr. Bragg is doomed to lose. And
also, I was listening to some expert legal opinions and some commentary from Ken White. He's from Osborne and Brown, an attorney here in Los Angeles, and he's no fan of Trump. But he even said that this is going to be an extremely difficult case to prove, especially with the Class E felony, because campaign finance violations are very, very difficult to prove.
Well, that's right. And you've got essentially two piles of money here. One that Trump may have collected for his election purposes. The other pile of money is his own personal money, if you will. So the question becomes, from which pile did Mr. Trump pay our girlfriend?
Miss Daniels.
What's her name?
Stormy Daniels.
Stormy. I was going to call her Snow White. From which pile was she paid? That's kind of the issue. And the problem, of course, we're going to have is that Mr. Cohen might try to trip things up and say it came from the election pile, in which case it could have some merit. Mr. Trump is going to say it was really for reimbursement to Mr. Cohen and never came from any direct pile, if you will. There was no direct payment from one of those two piles to Stormy Daniels. It went to Mr. Cohen.
And Mr. Cohen, who's also not necessarily covered himself in glory, because the man went to the joint for a line to the FBI. Also, prosecutors have to prove that Mr. Trump, quote, knowingly and willfully violated federal election law. Federal election law is very, very complicated. And also, perhaps, Mr. Trump, who's a very busy guy and probably not really concerned with the day-to-day incidentals with what goes on with campaign finance, he probably, and I'm just conjecture here, got advice from attorneys who were expert in campaign finance laws, and they told him you could do this. Well,
see, that's the problem. Whether or not, and I tried to look it up quickly for the show, I didn't find much. To what extent can a client, a naive client, if you will, someone who's not an attorney, if you will, rely on, if you will, bad advice from an attorney? In other words, if the attorney said, Mr. Trump, you're doing fine, just give the money to so-and-so and everything's fine, and it turns out it wasn't fine, all the authority wants to talk about is that Mr. Trump would have an action for malpractice. That's not the point I'm trying to get at, is whether or not Mr. Trump would be liable for taking bad advice and acting on it. That's the question that I have. Anybody out there, including Bruce, if you know the answer, give us a jingle.
Also, one last thing here, too. This case, Mr. Trump's case, bears some similarities to what happened with John Edwards.
Yes.
Who are referred to as the $600 haircut. He had something very similar happen with this. He's having an affair with Rachel Hunter while his wife was dying of cancer.
Right.
And he used money to pay off Miss Hunter to keep it quiet.
Right.
And I guess there's two things to talk about here. That's Mr. Trump is in order for it to be a campaign finance violation.
Yes.
They need to prove that the money he used to pay off Stormy Daniels, allegedly, was in order to keep that affair from the American people.
Yes.
Not to keep that affair from his wife.
Correct.
And what Mr. Edwards did when he went to trial under same and similar circumstances, he said, look, hey, I wasn't trying to keep this affair quiet from the public in order to influence an election. I didn't want my wife to know.
That's right.
It seems like Mr. Trump can have the same argument and win because Mr. Edwards was acquitted.
It seems that he can, unless he's already contradicted himself, and I don't know that he has, but that's absolutely right. And I don't know how anybody else would know unless Cohen is going to claim Mr. Trump admitted to me that he was doing this for election purposes. And who knows?
It should note, too, just for the essence of clarity, that Mr. Trump has still denied that he had an affair with Stormy Daniels.
Absolutely.
And I don't blame him because he's got Melania at home. Stick around, you guys. We'll be right back right after the break and talk about a little bit what Mr. DeSantis said about this whole situation. Stay with us.
You're experiencing pain, back pain, shoulder, elbow, or hand pain, pain from a sports injury. If so, schedule a visit with Dr. Michael Sheps, the leading expert in laser therapy for pain management. Call 310-873-4422 or go to drsheps.com. Experience Epic T, the breakthrough laser therapy system that Dr. Sheps developed to make you pain-free in less time. Laser therapy is a non-invasive, safe, and effective in-office procedure that penetrates deep into your skin without damaging the tissue. It perfectly targets areas of pain to promote fast, natural healing. Relax your muscles, ease muscle spasms, joint stiffness, and arthritis pain while increasing blood circulation. For over 25 years, Dr. Sheps has helped Olympic athletes and sports enthusiasts alike get back in the game. Schedule your visit with Dr. Sheps at his Brentwood office in California. Call 310-873-4422 or visit drsheps.com. That's DRSHEPS.com, 310-873-4422.
Are you ready to make a difference for the environment while helping the visually impaired at the same time? Then donate your vehicle to Heritage for the Blind today by calling 800-785-9618. Every donated vehicle will either be properly recycled in an eco-friendly manner or given a new life through reuse. Donating your vehicle is easy. Simply call 1-800-785-9618 and Heritage for the Blind will do the rest. They'll even arrange for your vehicle to be picked up at no cost to you. And for a limited time, when you donate your car, you'll receive a $200 restaurant voucher and a 2-night, 3-day hotel stay at one of 50 locations. Call 800-785-9618 right now to schedule your tax-deductible vehicle donation and make a positive impact on the environment while helping others. Heritage for the Blind, where every car donation counts and every person makes a difference. Call 1-800-785-9618 now.
Hi, this is Fred Dwyer talking about my favorite Italian restaurant, Angelo's and Vinci's at 550 North Harbor Boulevard in downtown Fullerton. A fantastic place to eat. Come inside and dine in our Italian town square, complete with a 10-foot Christmas tree. That's right, 10 feet. Enjoy our food made from secret family recipes. Pasta, chicken, seafood, salads, and our delicious pizza. Incredible desserts, including my favorite, the tiramisu, flown directly in from Italy. Feel the spirit at Angelo and Vinci's, 550 North Harbor Boulevard in Fullerton, California. Call 714-879-4022 or visit angelosandvincis.com. That's angelosandvincis.com.
And we are back in the Legal Lounge. Thank you so much once again for joining us. All past and previous sessions of this high-quality broadcast are available on YouTube, also available on Rumble. Search for Richard Nixon Live, the Legal Lounge, or CRN Digital Talk. You can find Richard right there. Also available as a podcast, crntalk.com/podcaster. Well, just to wrap a couple things up about this Trump indictment.
Yes.
Even though the fact is moot at this point because former President Trump has announced that he will appear in New York City at his arraignment come Tuesday, Mr. DeSantis had a very interesting thing to say.
Yes.
Ron DeSantis, governor of Florida, and also all but declared candidate for president in 2024. He said, quote, "The weaponization of the legal system to advance a political agenda turns the rule of law on its head. It is un-American. The Soros-backed Manhattan district attorney has consistently bent the law to downgrade felonies and to excuse criminal misconduct, yet now he is stretching the law to target a political opponent." Here's the key phrase, folks. "Florida will not assist in an extradition request given the questionable circumstances at issue with this Soros-backed Manhattan prosecutor and his political agenda." First of all, what are your thoughts on that, Richard?
Well, I think it's a nice gesture, but I don't know how meaningful it is in that Mr. Trump, I'm sure, will, unless he's incarcerated, will be making speeches from all around the country now for his election bid in 2024. And if he's not in Florida and he's amenable to service, he could be nabbed anyway. So it's a nice gesture on the part of Mr. DeSantis, but I don't think it's effective.
Yeah, this is a hypo in any case right now.
Yeah.
But I mean, there is something called the extradition clause in Article 4, Section 2 of the United States Constitution. Correct?
Absolutely.
It reads as follows: "A person charged in any state with treason, felony, or other crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up and to be removed to the state having jurisdiction of the crime." So this was, I think, kind of an olive branch DeSantis put out to Trump,
Right.
But not necessarily doesn't have any legal ground to stand on.
Well, that's right. And again, it doesn't quite say who in this case, the state of Florida, has to or will has the authority to turn Trump over to New York. I don't know if it's the executive authority or not, because it starts off talking about demand on the part of, in this case, the New York executive authority I suppose, and I'm just reading this by inference, that must mean that the executive in the Florida state, that is the governor, DeSantis, would have in other words, governor to governor.
Mm-hmm.
So, but although the statute doesn't say that, and of course, as you can see, Mike, this is one more reason why attorneys argue all the time, because the statute are not always clear.
Yeah, I mean, when I read the statute, when I read Article 4, Section 2, and it says, shall be demand of the executive authority,
Yeah.
I hear executive, and I think governor.
Right.
That's what I think.
Right.
So, real fast, though, Richard, this might have actually backfired on Mr. Alvin Bragg and the Democratic establishment that have celebrated this indictment. A poll was released from Quinnipiac this morning saying that Mr. Trump now leads Mr. DeSantis by double digits.
Oh, so I think so.
Amongst Republican primary voters.
Yeah. I think that unless the Democrats come 2024 have figured out another way to count ballots, illegal ballots, if you will, to make what Trump was a winner into a loser again, I think Trump is going to win overwhelmingly, because I think the people are finally fed up. They finally see what these Democrats are doing. They're desperate.
Do you expect any sort of retaliation if Republicans take control of the executive branch? Do you see the Republicans actually doing the same thing that they're doing to Trump right now?
I'm sorry, but I don't. I mean, the Republicans are so ingrained with wanting to be gentlemen and gentle ladies, if you will. They just don't have the blood to retaliate. However, what I would like to see is let's get Biden impeached now and get it over with.
For our articles of impeachment have already been talked about by Lauren Barber and others about specifically the situation at the border.
Absolutely. The border's wide open, and yet they refuse to acknowledge it. And if nothing else, he's not functioning well. But the point is, I think we have enough films and so on to show that he is ignoring his duty under Article 2, and he should be impeached.
There you have it, folks. I'm sure we'll be covering this moving forward in the weeks to come. So stick around. We'll be right back here in the Legal Lounge. As always, make sure to check out Richard's fantastic book, America, An Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. And we'll be right back right after the break. Stay with us.
Are you paying too much for term life insurance? There's a tremendous price war among the major term life companies. Rates have dropped dramatically in the past 2 years. For example, a man age 45 non-tobacco user, $1 million of coverage is only $75 per month, level for the next 10 years. Or a man age 50 non-tobacco user can buy $500,000 of coverage for a monthly premium of only $110, guaranteed not to change for the next 20 years. That's right, level rates for 20 years. And if you're a smoker, we have great rates for you as well. At the Term Lifeline, we specialize in policies of $500,000 and above. So if you're looking for new or replacement term life insurance, call right now for a free quote.
Rates and availability may vary by state. Sample rate quotes are based on preferred non-tobacco underwriting exam required to qualify. 800-349-6855. 800-349-6855. 800-349-6855. That's 800-349-6855.
When you really want Italian food, you have got to get to Columbo's. Columbo's Italian Steakhouse and Jazz Club, Colorado Boulevard, Eagle Rock. It's that little neighborhood place you wish was down the street from you. Today, it seems so hard to enjoy just a little bit of easy. So much of life seems to get in the way. But fear not, seekers of fabulous food and fun and thrill. Columbo's is Southern California's answer to Easy Street. Great grub with some of the finest steaks, the freshest fish awaiting for you to devour. Did I mention Columbo's family Italian recipes? Columbo's spaghetti bolognese, their chicken pesto ravioli, magnificent Mexico, and of course, the world's greatest meatballs. I can go on. But why go on when you can go on over to Columbo's and experience delicious and easy for yourself? Columbo's, of course, that little neighborhood place you wish was down the street from you. Columbo's, mangia bene.
Enjoy Tiki Live, the best cable alternative choice today, with hundreds of premium live TV programming, including ESPN, CNN, Fox News, Disney, AMC, Bravo, XF, OWN, and CRN Talk. Plus, no contracts and low month-to-month service. Tiki Live, servicing North America, including the Caribbean. To get started, visit TikiLive.com to order hundreds of channels, including CRN Talk, at a fraction of what you're paying today. Visit TikiLive.com. That's TikiLive.com.
Are you ready to make a difference for the environment while helping the visually impaired at the same time? Then donate your vehicle to Heritage for the Blind today by calling 800-785-9618. Every donated vehicle will either be properly recycled in an eco-friendly manner or given a new life through reuse. Donating your vehicle is easy. Simply call 1-800-785-9618 and Heritage for the Blind will do the rest. They'll even arrange for your vehicle to be picked up at no cost to you. And for a limited time, when you donate your car, you'll receive a $200 restaurant voucher and a 2-night, 3-day hotel stay at one of 50 locations. Call 800-785-9618 right now to schedule your tax-deductible vehicle donation and make a positive impact on the environment while helping others. Heritage for the Blind, where every car donation counts and every person makes a difference. Call 1-800-785-9618 now.
Hi, I'm Dennis Bono. Join me every Saturday at 6 p.m. and Sunday at 3 p.m. for the Dennis Bono Show live from the entertainment capital of the world, Las Vegas. Enjoy this fun-filled hour with my celebrity friends as they perform, visit, and have lots of fun with me in front of a live audience in the showroom at the South Point Hotel. Please join me Saturday, 6 p.m. Pacific, Sunday, 3 p.m. Pacific, right here on CRN Radio and CRNTalk.com.
And we are back in the Legal Lounge. Once again, thank you so much for joining us here. Richard, we got some feedback here on the show recently from some of our listeners. We'd love to hear from you guys. You can email Richard at pres37th@AOL.com or at info@CRNTalk.com. And we've talked a lot about Marbury versus Madison on this program. And so a listener asks, Richard, why are you okay with the Supreme Court overturning Roe v. Wade when you are not a fan of the Supreme Court overturning laws to begin with?
Well, that's right. And what they mentioned was you had no problem with overturning Roe versus Wade and the Dobbs case. So you affirmed that. And yet your position has been that you don't like Marbury versus Madison. That's true. But as you pointed out too, Mike, when I posed that question to you, you got it absolutely right. In one instance, what the court is doing when it overturned Roe versus Wade, it was simply correcting an error by its own body, that is the Supreme Court. But when the Supreme Court under Marbury versus Madison basically usurped power from the people and said that they, that is the Supreme Court, had power to void acts of Congress, that is still stuck in my throat, and it's still wrong.
It's the Roe v. Wade.
Yes.
Is not a statute passed by Congress.
Correct.
It's not an Article 1 Congress making a law.
Right.
This is Roe v. Wade was an interpretation the Supreme Court made in 1973.
Right.
Extrapolating the right to privacy from the Liberty Clause in the 14th Amendment, correct?
That's correct.
There wasn't a big vote on Congress where a bill goes to President Nixon at the time saying authorizing abortion nationwide. What Marbury versus Madison did in 1803 is it gave the Supreme Court, the power to invalidate congressional legislation.
Right. And what they did in 73 in Roe versus Wade is they piggybacked Griswold versus Connecticut. That was the case that basically said they recognized the right to privacy, which again does not exist in the Constitution. However, they found it by, I think I used that example in my book of like a Frankenstein monster, where they took the Second Amendment, Third Amendment, Fifth Amendment, combined them all and said, we recognize a right to privacy, which in the Griswold case was the right for a married person to buy contraceptives. So a few years later, once that right to privacy had been established, Roe versus Wade came into the foreground for the U.S. Supreme Court. They seized on that word privacy, which came from, as you said, the liberty word from the 14th Amendment due process clause, which says, no state shall deprive a person of life, liberty, or property. So they took that word liberty, they, through legerdemain, found the right to an abortion in there, the right to privacy, and that's how we got it. And now our current Supreme Court has seen fit to correct that. And again, I've thanked them, and I hope most people realize what an act of generosity it is for a government to return power from itself back to the people where it belongs.
And also, for clarification's sake, too, it wasn't that this current Supreme Court in Dobbs, it's the reason we call it the Dobbs case.
Yes.
Because it was Dobbs versus Jackson's Women's Health Center.
Correct.
The Supreme Court didn't go in there and actually look at Roe and try to change Roe. They just found a new precedent in Dobbs and applied that. And like you said, sent it back to the states where it was before 1973.
That's exactly right.
So there you go, folks. There is consistency to that logic.
Absolutely.
All right, let's move on to something else we briefly touched about last weekend, but it's something very, very important. And this has to do with McCulloch versus Maryland. What was McCulloch versus Maryland?
Well, yeah, we kind of gave it short shrift there. Now, remember, Marbury versus Madison was 1803, and that was the case where Chief Justice Marshall gave the Supreme Court the authority to overrule acts of Congress. 16 years later, in 1819, kind of as a return of favor to the Congress, there was the issue in that case, in the McCulloch versus Maryland case, was basically that McCulloch was trying to incorporate a national bank. And we had Chief Justice Marshall again, and he actually says, which I find very interesting. I'm going to read this out of my world famous book here just for a minute.
It's available wherever fine books are sold, Amazon.com, Barnes & Noble, America, An Illusion of Freedom.
Yes. Among the enumerated powers, we do not find that of establishing a bank or creating a corporation. Now, those are Chief Justice Marshall's words. So he doesn't find that in the Constitution. And therefore, if he followed the Constitution, the 10th Amendment would say to him very clearly, if it ain't in the Constitution, it must go back to the states. Now, let me say this real clear to make sure we get it right. The 10th Amendment says the powers not delegated to the United States by the Constitution, nor prohibited to the states, are reserved to the states respectively or to the people. So if Chief Justice Marshall had obeyed the Constitution, he would have said, sorry, folks, you can't incorporate a national bank because the Congress does not have that power. It was never granted to him under Article 1, Section 8 or otherwise. However, what he did is he looked at Article 1, Section 8 and looked at all 17 of the enumerated powers, and then he looked at number 18, which is the so-called necessary and proper clause, which we'll get into in a minute, was misinterpreted, and said, therefore, I am going to take the words necessary and proper, and I'm going to say just convenient, or what else, Mike?
Well, we're up against the break, so
Okay.
we're gonna talk about this. So just real fast to summarize, we see in 1803, we see the courts expand.
The word's appropriate. I'm sorry.
Appropriate. So we see in 1803 that the Supreme Court gave itself power to overthrow the laws of Congress. Now we see in 1819 with McCulloch versus Maryland that Marshall gave powers to Congress that are not enumerated in the Constitution either.
Exactly.
And we're going to talk about more of that after the break. Stick around, you guys. We'll be right back.
No more mold, no more damage, no more outdated old bathroom, no more slipping and hurting, no more stress. Make your ordinary bathroom extraordinary for only $99 per month. New shower, new door, new tub, new wall, new anti-slip technology. Be stress-free. Call 800-973-5411. BCI Bath and Shower is made in America for the highest quality. Ask about our military and senior discounts. Your dream bathroom in as little as 1 day. First 50 callers save $1,500 on a never clear glass treated door. Call now for free premium color upgrades. 800-973-5411. Call BCI Bath and Shower, the leader in bathroom remodeling. Be smart, safe, and stay a step ahead of inflation with our interest-free financing options. Call 800-973-5411. Love your bathroom with free upgrades. Call 800-973-5411. 800-973-5411.
Hi, this is Fred Dwyer talking about my favorite Italian restaurant, Angelo's and Vinci's at 550 North Harbor Boulevard in downtown Fullerton. A fantastic place to eat. Come inside and dine in our Italian town square, complete with a 10-foot Christmas tree. That's right, 10 feet. Enjoy our food made from secret family recipes. Pasta, chicken, seafood, salads, and our delicious pizza. Incredible desserts, including my favorite, the tiramisu, flown directly in from Italy. Feel the spirit at Angelo and Vinci's, 550 North Harbor Boulevard in Fullerton, California. Call 714-879-4022 or visit angelosandvincis.com. That's angelosandvincis.com.
And we are back in the Legal Lounge. Thank you so much for joining us here, talking about McCulloch versus Maryland. And what really emerged here was the necessary and proper clause. Necessary and proper clause. So there's 17 enumerated powers that Congress was granted through the Constitution, but that number 18 was hereby known as the necessary and proper clause. It's Article 1, Section 8. It states that, quote, "The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or any department of officer thereof." What does that mean?
Well, what Chief Justice Marshall did is he said, look, we don't want to embarrass the federal government because, look, they have the power to declare war. They have the power to coin money and so on. We should allow them to incorporate a national bank. And so we're going to take the words necessary and proper, redefine them to mean appropriate and timely or whatever. Convenient and appropriate is what I'm trying to say. So he redefined that and simply made an argument that, in fact, the national government does have power to create a national bank, and went ahead and did it. And, of course, the president, no longer President Jefferson, was really upset, and he had a few things to say about that.
It should be noted that Mr. Marshall, Chief Justice Marshall, was a Federalist.
Yeah, absolutely.
And Federalist at that particular time in American history meant that Federalists, and correct me if I'm wrong, they were more attuned to a strong central federal government.
Absolutely.
Where the Democratic Republicans, I know that sounds weird now, but that's how it was back then.
Right.
The Democratic Republicans were, in our view, I think, more aligned with the Founding Fathers' convictions going into the formation of this union.
Absolutely.
Where it was a loose confederation of states.
Correct. And this is what Jefferson had to say. He was upset over this decision. He said, "I consider the foundation of the Constitution as laid on this ground. that all powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states or to the people. Now, of course, that's simply a restating of the 10th Amendment. But then what he says is very dynamic. To take a single step beyond the boundaries that specially drawn around the powers of Congress is to take possession of a boundless field of power, no longer susceptible of any definition. So he was saying you can't do that. The 18th clause, Article 1, Section 8:18, the necessary and proper clause, its intent was to simply modify the first 17. It was not a separate grant of federal power, which is what Chief Justice Marshall did. He simply said, we find something new and unique in number 18, the power to incorporate a national bank. And Jefferson said, and of course I believe Jefferson was right, all the 18th one did was to amplify the first 17. For instance, one of the 17, I think it might be 3 or 4, Article 1, Section 8, 3 or 4, basically talks about establishing a post office and a post roads. Number 18 simply meant that the Congress could also do whatever was necessary to carry into effect establishing a post office.
1 through 17.
Yes. And in this case, post offices and post roads. So it had to be necessary and proper. That is to say, without the necessary and proper clause, then sitting by themselves, they would be nugatory. They would be meaningless. You need number 18 to carry out the first 17.
Well, what Marshall did in this McCulloch versus Maryland is pretty much say that number 18, the enumerated powers, the necessary and proper, says we can do whatever we want.
Exactly.
It's like, okay, we have, 1 through 17, which is like you said, establish a post office, declare war, print money, stuff like that. And then number 18 was being like, okay, and we can use what we deem appropriate to enact in a convenient manner the first 17.
And of course, Jefferson said, well, what the hell's the use of having the first 17 if you can do whatever you want under number 18? And of course, his logic is, as usual, impeccable.
Exactly. And Jefferson went on and he warned against the construing the necessary and proper clause so broadly as to justify the assumption of undelegated powers by the general government. He also said something interesting, that free government is founded in jealousy and not in confidence, and therefore urges that no more be heard of confidence in man, but bind him down from the mischief by the chains of the Constitution. In other words, the states should not trust federal officials with non-constitutional powers simply because those particular federal officials might be trusted to use those powers benevolently.
Yes, he also said, look, it's possible that if we use number 18, that this government would do very, very good things for the country. But that is not the point, because that same body of power could use it to do bad or evil things as well. And the founding fathers were clear to say they could only do what was necessary and proper, not what is convenient and appropriate.
Exactly, because what is convenient and appropriate
is a far cry.
100%. So there you go. I just want to get this quote in from Marshall. He says, although among the enumerated powers of government, we do not find the word bank or incorporation.
Exactly.
We find the great powers to lay taxes and collect taxes and to borrow money, regulate commerce, to declare and conduct a war, and to raise and support armies and navies, the sword and the purse. All the external relations and no inconsiderable portion of the industry of the nation are entrusted to its government. So there you have it, folks. Stick around, you guys. We'll be right back, wrapping things up here in the Legal Lounge. That fantastic book that Richard was quoting from is America, An Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. Stay with us.
Let's talk about your credit cards. When you first start using them, it's a slow drip. You make charges, then more charges, then bills come, and they keep coming. When you open your statements, the floodgates come pouring in. You realize you have more credit card debt than you can afford, and you're barely making the minimum payments. Wouldn't it be nice to make one affordable payment and have all your credit card bills covered? Make this free call and learn our responsible way to get your credit card bills paid and under control.
Sponsored by Consumer Education Services, a nonprofit organization.
800-876-3643. 800-876-3643. 800-876-3643. That's 800-876-3643.
CESI is not a loan company. The establishment of a debt management plan may adversely affect your credit rating. Non-payment of debt may lead creditors to increase finance and other charges to undertake collection activity, including liquidation.
When you really want Italian food, you have got to get to Columbo's. Columbo's Italian Steakhouse and Jazz Club, Colorado Boulevard, Eagle Rock. It's that little neighborhood place you wish was down the street from you. Today, it seems so hard to enjoy just a little bit of easy. So much of life seems to get in the way. But fear not, seekers of fabulous food and fun and thrill. Columbo's is Southern California's answer to Easy Street. Great grub with some of the finest steaks, the freshest fish awaiting for you to devour. Did I mention Columbo's family Italian recipes? Columbo's spaghetti bolognese, their chicken pesto ravioli, magnifico, and of course, the world's greatest meatballs. I can go on. But why go on when you can go on over to Columbo's and experience delicious and easy for yourself? Columbo's, of course, that little neighborhood place you wish was down the street from you. Columbo's, mangia bene.
Do you want to fly somewhere, anywhere in the world? Smart travelers call myflightsearch.com for the best deals on flight tickets. Going to Manila, Bangkok, London, how about Singapore? Call myflightsearch.com for the lowest flight tickets available. What about a local vacation? Let's say you want to fly to Vegas, Orlando, Miami, Los Angeles, or Denver. Pick up the phone and call myflightsearch.com right now. We have exclusive deals that you can't find anywhere else. The only way you can get these low airline prices is by calling us. We have so many low prices available, we can't possibly tell them to you right here and now. If you're flying somewhere anytime in the next 6 months and you want the lowest airline ticket prices anywhere, you owe it to yourself to save a ton of money. So pick up your cell phone and call myflightsearch.com right now.
Call 800-445-3166. 800-445-3166. That's 800-445-3166. Call now. 800-445-3166.
And we are back in the Legal Lounge. Thank you so much once again for joining us. We really appreciate it. We want to kind of switch gears here a little bit. This is a letter that went viral a couple of years ago, famously featured in Barry Weiss's Substack, but also has been gaining traction with so much we've seen with this woke school stuff going on. This is a letter from a father of a student, a young girl who was a student at the Brearley Academy in New York City. This gentleman's name is Andrew Gutman, and he got fed up. First of all, this school, very expensive. To send your kid to this school, K through 12, you're spending about $700,000 total.
Oh my God.
And so Mr. Gutman was sick and tired when he can spend that money in a vacation home rather than having his daughter being indoctrinated by quote unquote woke politics. Richard, I understand you have some passages you'd like to read from this.
Well, several. Now, I'll start off with this one that Mr. Gutman says, I object to the idea that blacks are unable to succeed in this country without aid from government or from whites. Brearley, that's the name of the school, by adopting critical race theory, is advocating the abhorrent viewpoint that blacks should forever be regarded as helpless victims and are incapable of success regardless of their skills, talents, or hard work. What Brearley is teaching our children is precisely the true and correct definition of racism.
He goes on as well with some other passages here. Particularly this one stuck to me. I object to the gutting of the history, civics, and classical literature curriculums. I object to the censorship of books that have been taught for generations because they contain dated language potentially offensive to the thin-skinned and hypersensitive. I had parenthetically, he's probably talking about Huckleberry Finn. Sometimes something that has already happened in my daughter's 4th grade class. I object to lowering of standards for admissions of students and for the hiring of teachers. I object to the erosion of rigor in classwork and the escalation of grade inflation. Any parent with eyes open can foresee these inabilities Inavailabilities should anti-racism initiatives be allowed to persist?
If we have time for one more, Mike.
Please.
Again, I object to Brearley's vacuous, inappropriate, and fanatical use of the words such as equity, diversity, and inclusiveness. If Brearley's administration was truly concerned about so-called equity, it would be discussing the cessation of admissions preferences for legacies, siblings, and other families with especially deep pockets. If the administration was genuinely serious about diversity, it would not insist on the indoctrination of its students and their families to a single mindset, most reminiscent of the Chinese Cultural Revolution. Instead, the school would foster an environment of intellectual openness and freedom of thought. And if Brearley really cared about inclusiveness, the school would return to the concepts encapsulated in the motto, One Brearley, instead of teaching the extraordinary divisive idea that there are only always two groups in this country, victims and oppressors.
And lastly, Mr. Gutman, and I'll just paraphrase this last one, he says, lastly, I object with a strong sentiment as possible that Brearley has begun to teach what to think instead of how to think.
Yeah, exactly.
And I think that's a problem we're seeing in a lot of institutions.
Absolutely.
If you guys want to know more about Mr. Gutman, check out his website, speakupforeducation.org. That's speakupforeducation.org. You can read more about Mr. Gutman and his viewpoints. Richard, we're out of time. Thank you very much for today.
Thank you very much.
And make sure to check out Richard's fantastic book, America, An Illusion of Freedom, available on Amazon.com, Barnes & Noble, and on iTunes. You can follow him on Twitter at Richard A. Nixon1, at Parler, at PRES37TH. Email him at PRES37TH@AOL.com. And we'll see you guys next week in the Legal Lounge.
Are you tired of your favorite talk show sounding